Hi, this is Jessica Nielsen with Business Law Online. This is Jessica's key points to Chapter 1. There were three main points to Chapter 1 that I hope you got. I'm going to review them for you here. The first one is the idea of common law and its sources of law in the American legal system. The second is stare decisis and the concept of precedent. And the third is the idea that we can classify laws according to the classifications that the chapter describes. First, common law. As the book points out, the American common law system came from England. We borrowed it with not many changes, and it's a system of primarily judge-made law regarding individual cases that are decided by judges on individual sets of facts. The common law system is to be distinguished from the civil law system. The civil law system is a system of laws that is primarily statutory, and it's used by much of continental Europe, such as Germany, France, Italy, and other countries, and also Louisiana, which is kind of curious because Louisiana borrowed its legal system from the French Napoleonic Code. The main difference between common law and civil law is that the civil law is primarily statutory, does not have a system of well-developed cases and case law using the precedent system, and whereas in the common law system, judges are hugely important in deciding individual cases, in the civil law system, scholars are very important. People who are in the legal profession, who are academics, they interpret the statutes and their interpretations have a lot of weight. So ultimately there are four main sources of American law. The United States Constitution, which is the primary source of law that organizes our entire legal system in the United States. If you recall, the U.S. Constitution set out a tripartite or three-branch system of government: the legislature, the executive branch, and the judicial branch. The legislative branch, specifically Congress and the House of Representatives on the federal system, get together and make laws called statutes. Statutes are rules that apply generally to all people, and they are general in description. For example, a law like the Clean Water Act that says you can't dump pollutants into clean waters in the United States. Then there is the executive branch, which at the federal level is governed by our president, and the executive branch issues treaties with other countries and rules called executive orders, which are more limited and primarily affect executive agencies. The judicial branch, the third branch, is the one that we spend a lot of time talking about here in business law, and it is the one branch that is governed by judges. There's obviously federal judges and state judges, and they take the statutes issued by the legislature and apply them to individual cases with specific fact situations, and they produce what we call case law. And then, as this slide refers to, administrative regulations and decisions come from agencies. These are sometimes called the headless fourth branch of government because agencies are created by the legislature and enforced by the executive branch, and they have been delegated a lot of authority to interpret the statutes of the legislative branch. So what we learned from Chapter 1 is that there are two co-equal systems, a federal and a state system. The federal government has predominance or priority over the state, and the U.S. Constitution is the ultimate authority over all of the laws in the United States. We learned that the U.S. Constitution is interpreted by the Supreme Court of the United States, and they determine if a law violates that Constitution, and if so, they strike it down. So the Supreme Court has power over federal law and state law to the extent it conflicts with the U.S. Constitution. Let's talk specifically about the third branch of government, the judicial branch, and the cases that it develops. First of all, we have this concept of stare decisis and precedent. Those two mean kind of the same things. Stare decisis means let the decision stand. Precedent just means it's a system, it's a judicial system that looks to old cases to interpret new cases. So as the slide says, stare decisis makes the law more stable and predictable, and it does make it easier for courts who don't have to completely reinvent the wheel. They just take an old decision and try and decide if the new one is within it or not. They compare and contrast prior cases, and this is in fact the central feature of the common law system. The basic idea is once a judge has decided something in a case, that should be binding, at least as to similar cases in the future, must be followed. I'm an English major, so I always have metaphors and images that help me understand things. And one way I understand common law is to think of the concept of accretion. That's a word that just means the depositing of sand grain by grain. I think of on a beach. Picture cases being deposited on a beach, individual case by individual case. The facts of each case are different, and together when you read a whole line of cases, you can understand the path of the law. You can understand how a doctrine is developed, just like you might develop a particular curve on a beach using sand. Let me make a quick example of how the idea of distinguishing, comparing, and contrasting takes place. Imagine you live in an infested apartment and you go to the court and you say, please, court, tell me that my apartment is uninhabitable according to the State Landlord-Tenant Act because it has 800 spiders in it. And the court says, yes, we agree. 800 spiders is definitely an uninhabitable apartment. You shouldn't have to pay rent and you should be able to move out and break your lease. Now, say a second case comes down, and in that case there are no spiders, but there are bed bugs, and there aren't 800 of them, but there are 500. So as you can see, that situation is not identical to the first case, but it is similar. What the court does is look at the prior spider case and try and figure out if that decision should apply in the bedbug case. The court says, well, gosh, are spiders similar to bedbugs? Is that number high enough? Is the rationale that we used, the reasoning, the decision-making process that we used for the spiders the same as we might apply in the bedbug situation? So basically, lawyers argue that either the case is similar or it's not, depending upon whether they like the outcome. So in order to determine if the first case applies, the lawyers and the judges are going to have to figure out, do spiders and bedbugs have enough in common that it makes sense to apply the same rule to them? And so there, cases are decided on a narrow factual basis with each individual case, and a whole body of law is developed around the word uninhabitable that is in the State Landlord-Tenant Act. Does that make sense? I always like to have images that help me. The third point we'll talk about is the classifications of law, and that is the idea that you can classify laws into these different types. And it's helpful to think about this when you're reading the newspaper or watching the news and trying to understand what legal principle is at issue. As the slide describes, criminal law is primarily law that is attempting to punish people for the harm to society of certain behavior, whereas civil law is really about money. It's about trying to make somebody whole when they've been damaged by somebody, either intentionally or unintentionally, through an injury like a car accident or a breach of contract. So one type of law is going to be dealing with the harm to society, and one is a private law or private harm. And you can often identify the difference between these two cases by looking at the title of the case. If it says U.S. versus so-and-so, it might well be a criminal case. If it says state versus or Washington versus so-and-so, it could be a criminal case, because again, it's the state or the federal government that is trying to remedy the harm to it. Whereas if you see a civil case, it might say Jones versus Smith or something like that, and it might be private parties trying to redress their own harm. Then you have substantive versus procedural law, and the idea there is that there are some laws that give you rights and some laws that tell you how to enforce those rights. If you think about the game Monopoly, which a lot of people play, the goal of the game is to get a whole lot of money by buying and selling properties and putting hotels and mortgages on and buildings on properties and collecting rent. Well, that's great. So that would be like the substantive law. It's like the game, whereas the rules of Monopoly, when do you pick up the cards? When do you how many dice do you use? How do you give out money? Those are like the procedural laws. So it's like the rules of the game versus the game itself. An example would be a federal civil rights law that gives people the right to sue when their civil rights are violated, versus the federal rules of civil procedure, which are the rules that tell you how to file a claim under the civil rights laws. And finally, there's the distinction between public and private law, which basically just helps you think about the government setting a statute or a regulation that sets the duties of the government to its citizens, like the EPA issues rules about the Clean Water Act, or it tells you how to operate your business, versus a private law, which is like maybe breach of contract law, which says how you regulate your contracts between parties. So I hope this helps you think about the 3 key points of Chapter 1. I'll do another one of these regarding Chapter 3, and I'll keep doing them. Thanks.